Good morning, everyone, and welcome to another New Hampshire Business Review webinar. Today's topic, Legacy on the Line, Case Studies in Succession Crises. I'm Ernesto Burden. I'm the publisher of New Hampshire Business Review. It's my pleasure to welcome you today. We're going to have a fantastic discussion sponsored by Shaheen Gordon, attorneys at law. Our panelists today, who will be talking through the legal aspects of business succession, are Kirsten J. Allen, William Baker, and Sean O'Connell. And so, William, Sean, Kirsten, why don't you all turn on your cameras and join us here. We're going to get started. And our format today, each of these speakers will be presenting a case study, and then the three of them will be discussing that case study together. So things that can go wrong in business succession and things that have gone wrong, and then, of course, things that they would have done to make those go more smoothly or better or not turn into crises. Welcome.
Thank you, Ernesto.
Morning.
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 Okay, and so who will be presenting the first case study?
Well, I'm going to start out by giving just a broad overview and kind of frame the discussion here today and talk about, what succession planning is, what it isn't. And succession planning is not a singular business event. If done properly, it's something that can purposely unfold throughout the course of a career and then beyond that. And I think that my colleagues and I would all agree that you can never start planning for the succession of your business too early. And by that, I mean, as you have this idea for a business in your head, what is that entity going to look like? You can start there. How are you going to structure the business? Will there be an operating agreement, bylaws? How is that going to play into things? It's never too early to start looking into that. So, as we move forward to this, I think it's important to understand that. And I think it's also important to understand that we're going to go through some kind of case studies here. We're going to talk about succession planning in general, but there is no really one size fits all model of succession planning. Each business is unique. The members who comprise that business are all unique. So it's really a business specific type plan you want to implement. That's not to say there aren't some guiding structures that can help with that planning, but really it is a very individual type endeavor. With that said, I will turn things over to my colleague, Sean O'Connell.
Thanks, Will. So we're doing case studies today, and business succession planning can mean lots of different things, lots of different people. It can be, I'm going to sell my business in a few years. What should I do to prepare? I'm going to give it to my employee. What should I do to prepare? I want to retire. How do I get out of here? I'm having a problem with my colleagues in my business. How do I extract myself from it? I want to get someone else out of here. Things like that. There's a lot of different ways that business succession planning can come into play in a business. And I know there are a lot of folks on here today. You probably have different things that brought you here. And if we don't cover the specific thing that brought you here today, any of the three of us are available to discuss other specific questions offline. Your contact will be available. But we're going to just kind of go through some examples that we have been through. Some of them have been litigation, some of them have been more negotiation based, but all of them are cases where planning was not done in such a way to avoid future problems, and those problems rose to such a level that we became involved, and that's not where you want to be, because it creates a lot of cost for one thing, and it creates a lot of acrimony, and that's especially tough if it's between family members. And a couple of our case studies are going to include actually, I think all three of the case studies are family based. We have lots to choose from, but we chose just these three today. So I think that's sort of the landscape, and we hope that we get some questions along the way. And why don't we have Kirsten lead off with the first one?
Okay, yeah. So I think interesting. You pointed out the three that we chose had are between family members, and I do think a part of that is because it's a situation where you don't necessarily think that you need to plan, or you don't necessarily think that you need everything in writing because you trust the people that you're working with, right? And so you assume that the situation won't devolve into a mess, or you think everyone will be able to work with each other, and then sometimes that doesn't turn out to be the case. So that is what happened in our first case study. This is one where a father had a small business, and later it was given to his children through his trust. So in this case, we represented a client who inherited a quarter interest in the small business through her father's trust, along with three of her siblings. In that case, the father, this client's parents, didn't put any management terms of the business or any terms related to conflict resolution in that trust. In that case, again, it's because likely that father, this parent, didn't foresee any future conflict between those children, and assumed that that everything would go smoothly, or if the business needed to be sold, or one person would manage, and that would run smoothly, because certainly the children would get along in the way that he hoped, which was not the case. So in this case, there was one sibling on the ground managing the business, and the rest were sort of passive owners. And both sides believed that one was mismanaging, or that the other were perhaps breaching their duties to the other, and we became involved. So the matter ended up in litigation. So this would have been a good opportunity for the father to have more thoughtful succession planning to avoid this problem. Sean and Will, do you have thoughts how this could have been avoided? We could not have had this sort of conflict, and perhaps we could have not been involved at all, or we could have been involved earlier in the process to avoid this issue.
Yeah, I have some thoughts. I was deeply involved in this case, and I think that these four siblings, there were some more of the complications that we don't need to get into, but there were essentially four siblings, and those four siblings created companies after their inheritance. So they were owners, substantially equally owners in these LLCs that owned real estate and owned a business. And Dad assumed that everyone was going to get along, and it would be a continuation of his legacy. And he had a very long legacy. In fact, I think he was his second generation to own this property in New Hampshire. And it fell apart. It ended up kind of being a three siblings against one sibling, and became very unpleasant. And so far as I know, it continues to be an unpleasant relationship between the four of them. The four sisters had an opportunity to arrange their own relationship going forward as well, and they failed to do that in any kind of meaningful way. They created LLC they thought protected them, and it did for liability and other purposes. They got LLCs because they thought they would get better tax treatment, and they did that. That worked as well. What they did not do was to install into their operating agreements mechanisms to deal with conflict or dispute resolution. So if we have a manager, how do you remove the manager? What's your dispute resolution mechanism? And there may not be. You can give a good effort at that, but if the dispute becomes overwhelming, the dispute resolution still may end up in someone exiting the company. And to that end, they did not include anything within their operating agreements which dealt with exit. And exit is one of the first things I talk about in preparing for today. looked back at the NHBR website and I found that I did one on the same subject probably 2, 3, 4 years ago. And I talked a lot about exit in that one as well. So if anyone has seen that one, I'll try not to repeat myself too much. But I think that when they created this, they all assumed that dad's wishes of them carrying forth this family legacy would just happen. And then it didn't. And they one left and they could not get along as to how she would leave, what she would be paid, any of the terms of an exit, the value of the company, nothing. And if they had done that, let's say they had installed in their operating agreement, which is something we like to do, is a different mechanisms to pay someone out when they leave. They might leave on retirement, which is kind of a euphemistic word because retirement might be, it might be a conflict based, we can't get along anymore and someone's got to go, but we'll call it retirement. Another one's death. Someone leaves the company. How do you deal with that? Another would be could possibly be disability. In many instances, very small companies have very few owners, and those owners do everything at the company. If one becomes disabled and can't do the job any longer, the remaining person may want to be able to buy that person out. And there's kind of a fourth category of involuntary transfer, which is really attenuated and unlikely. It deals mostly with bankruptcy and sometimes with divorce. Not particularly relevant for today. But what they could have done was to create those scenarios, each of them, and say, if someone wants to leave, they need to make an announcement of their exit. And then the other members or the company itself have to buy them out. Well, when? So you put that in the operating agreement. For how much? Well, we put in evaluation methodology. We're going to hire a appraiser. We're going to rely on the company CPA. We're going to do something that we've agreed upon ahead of time, so we don't have a dispute now as to how do we value this place, and then how do we pay it, because that's kind of one of the biggest questions. Someone's leaving with, I want all my money right now. Fair enough, right? But if you take all your money right now in a small business, you probably kill the business off because it may not even have the cash. But if it does, it's probably a very significant portion of the value of the entity, and that would kill it. So we tend to write in terms, so something like 10% down or 15% down, something like that, with a promissory note over a period of say 48 or 60 months, some reasonable interest, security, maybe back into the equity of the company, or security. Sometimes there's a personal guarantees that go with it. And that then kind of opens the whole thing up. And so instead of the client coming to us and saying, this has blown up, I'm being kicked out, I can't manage, they're not paying me, they're not letting me have records, it's just it's a mess. And then we're in uncharted waters at that moment. We have to use the statute. In that case, 304C is our statute in New Hampshire, which provides some guidance, but it does not provide buy-sell language. It allows judicial dissolutions of LLC, but that is expensive. That is time-consuming. If they had this there, our next step would have been to let institute proceedings per the terms of the agreements. Our client announces her exit. She's now, you are now required to buy her out in this many days. We are going to do we're going to begin the evaluation process per section whatever of the agreement and go forth. That case probably took us, I don't remember, Kirsten, it was at least a year.
I think it was a year and a half, 2 years.
Yeah, and it was the timing of the case was somewhat COVID affected. So it took a little longer than it might have otherwise. But even if it went on a normal course, it would have been at least 12, 14 months from the date the problem arrived at our doorstep to its end. And it doesn't start on the day it arrives here. The problem has been stewing for months before that. So
I think, and to kind of what you're talking about. So you've been talking about sort of failures of, because when they inherited the business, they created an LLC which did not have the conflict resolution provisions among the siblings, right? So I think there's sort of two missed opportunities. I mean, it was when they inherited the business, there were no terms, right? And I think that was maybe a missed opportunity in succession planning from the father, right? It could have been done better at that tier, and then among the four siblings, that once again another opportunity when they could have had sort of that conflict resolution among them, which was not present. And so again, there's sort of two missed opportunities, which put them in the position where they were, which was expensive, acrimonious, litigious, and all of that, right? So it's sort of two missed opportunities in this case.
Yeah.
Having not worked on that case, did the siblings know that the business transfer, their interest was coming?
Yeah,
And I ask that in the
to
context,
my knowledge.
you know, do things intentionally, I think is obviously incredibly important in business succession planning, and you know, making sure you have buy-in from those who stand to inherit and then take over, you know, the business is essential. So to the extent that they didn't know it was coming, I think is not a good way to do things. More generally speaking, this came through a trust, you said, and I can think of, gosh, any number of reasons why business planning through estate planning is not the most ideal way to do things. And again, that goes to the intention. You want to make sure you have buy-in on the front end of things. Sean, Kirsten, can you think of any situation where business succession planning through estate planning would be beneficial?
Oh, I think that estate planning, you know, when we think of estate planning, we think of trusts and wills, and that's kind of the end of the thought. It may be, you know, there are other ways to do it. You know, in this case, Dad, who assumed everything would be fine, just created a trust and gave everything to his kids. Hard stop, and didn't consider what else was happening. If he had considered there could have been issues, he could have had a business existing ahead of time. He could have involved his kids in the business ahead of time. He could have done you know, some succession planning where he conveyed interest in things to them prior to his death, where he then would have had some participation and control over the situation as it grew for them. And he didn't do any of those things. He could also just have done things such as consulting with them as to what are you going to do, which he didn't do. You know, just he was very much hands off. Now you can't blame the guy. You know, he had this had happened to him, right? And he got his interest, and he had no issues, right? And so he's, well, I'll just create a estate plan, give it to my kids. We'll be fine. You know, I don't know the family and wouldn't know whether there was some other markers that would have tipped anyone off to think there might have been problems in the future. But I mean, we're in a kind of a defensive business here, so we try to look at these situations in worst case scenario ways. And so, you know, if the dad's going to convey this to these people and they're going to run a business after, and they were going to run a business after, there were ways to try to be sure that it would be successful, and he just didn't undertake any of them. And then the second miss was when the kids created their business. They had an opportunity, and they did do it through counsel. Their operating agreements did not contemplate problems. They contemplated voting and management and distribution of profits and tax matters and things like that, but they did not contemplate problems, and so they were adrift when things got very, very messy. So there were at least two opportunities to answer that question, Will, about where things could have changed, and both the problem with litigation, the money, and all that kind of stuff. That you know, it still would have been a problem. It just would have been much more orderly. But now those family is still blown up. You know, these three of the siblings don't talk to the fourth, and probably never will. These aren't young people. So it's tragic at the same time.
Can I ask a question of all three of you? You mentioned that all three of the case studies that you bring are related to families. And is there something in human nature or in the nature of people to typically be polite or want to preserve relationships that would prevent people from wanting to bring up the need for this in advance? So let's say we're putting together this succession plan and my siblings and I are in it. If I say to them, we need an exit thing in case this all goes south and we all disagree, are people concerned to do that because they don't want to hurt somebody's feelings or suggest they don't trust them?
100%. Yeah, absolutely. Seeing that many times over, and I think one of the values that counsel should bring to that discussion is raising that unpleasant or that question in the group, so everyone can address it, but no one feels as though they are the person who raised it. I don't trust you. You're not saying I don't trust you. You're saying this lawyer I'm talking with is suggesting we should consider this thing. But yeah, that happens lots of times. That people starting a business are not in any way contemplating the end of the business or the end of the relationship, and that succession end of it can be a huge problem. Even even if it's not acrimonious, let's just say two people start the business and one person has some life event and they decide that I don't want to be here anymore. Right? It's not that there's a fight between them. They just one of them wants to go, and they haven't addressed that. They haven't contemplated that issue. Even something as simple as that feels weird when you're starting. What if we break up later? It's like a prenup, right? It's awkward. But it is just like prenups. It's a pretty good idea.
And those issues aren't going to go away just because you don't address them. So, it's important to think, who are the stakeholders in your business? It's not just you, it's the successor business owners, it's your clients. So while none of us maybe like to have these uncomfortable conversations, they're absolutely necessary because you are working to protect both the business, the future business owners, and your clients as you move forward.
And your heirs, I'm going to throw in an example, a case study that the three of us didn't talk about, but I'll quickly throw it in. This was not a family one, but there were a 3-member LLC. 2 of the members were essentially at war with one another. The third was fairly agnostic about where things went. He wasn't really didn't really care. He just wanted the business to succeed. But that third guy, then got sick and fairly quickly died of cancer, leaving his wife, who was not a fan of the other 2, as the third member at the table. And the mess couldn't have been bigger. They couldn't agree on the color of the sky, and it literally took years for it to resolve. And during the time that it took to resolve, this once successful business failed. And it wasn't because of business conditions or markets or the product they were selling or any of those things. It was the relationship and the fight between them that killed the business off, and solely because they hadn't considered it. So for succession purposes, in that example, that guy who got cancer, he did not have any plan. He died. His wife then owned his third of the company. And she's just, she's now a 1/3 owner of the LLC. And it was, again, it was a very successful company. And, the owners owned it, believing that the company was essentially their retirement plan. And it was, it was a successful entity. And because they didn't plan for problem, it ended, and it ended. There were bankruptcies or personal bankruptcies that came out of that. It was terrible.
And was that was a fairly successful business prior to the?
Very, yeah. They were very successful. They were high flying. They were doing very well, very, very well. And they, all the dispute. I think mostly it was the distraction and the distraction of how they managed each other, then permeated throughout the business. Vendors and customers became aware of the problems. Internal issues caused delays in deliveries, and all kinds of stuff kind of went sideways. But it went from a company. I would say my best memory, this is quite a few years ago, could be 10 years ago, maybe more. The owners of that company were taking home well into six figures each annually on that business. Probably, I don't know, it was $500,000, but it was they had good salaries for each of the, or distributions for each of the three owners, and then poof, all of it's gone. And again, you don't avoid the conflict, you manage it. And if that had been better considered, that could happen. And that wife who ended up at that table with those two guys, she could have gotten out, but she had to ride that thing into the ground. But if there was like I discussed earlier, if there was a provision that provided that at death that the owner would be bought out, and that can also be paid for through insurance. But if that owner was bought out at the time of death, she would have gotten money. Those last two guys would have been there, and she would have been great. But she wasn't, and
she was unwilling to be bought out, is what you're saying?
Nobody could agree on anything. By the time the third member died and the wife came in, no one could agree on anything at all, and it didn't have itself within the agreement itself, and it was way too late given their acrimony to install one. Right. So you just ended up with nothing.
Did you say there was no operating agreement?
There was.
There was.
There a lot of, you see an awful lot of operating agreements. That's a good point, Will. There's an awful lot of people who come into our business with operating agreements that they got online or they got somewhere else that they didn't want to pay for, don't really need it, and they're just fine. What do you really need with these things? And those, I've never seen one of those off-the-shelf type LLC operating agreements that addresses exit from a company. They never do. And so they're, honestly, I don't really know what. I suppose they could serve as a bit of a shield on a veil piercing claim or that type of thing, or maybe they address who's the manager, that type of thing, but they really don't do much more than the statute would do for you without them.
Right.
It would certainly be our recommendation that you include that language in any operating agreement. And again, that goes back to starting to think about succession planning the minute you start that business.
Yeah, I've been doing these things or writing articles and so forth on the subject, suggesting that the day you consider exit is the day that you start planning for the business. It's got to be part of the entirety of the plan from the beginning.
Right. That one that you just mentioned does remind me of the third case study, which is out of order, but I don't know if we want to go into that one. Do you mind if we go into that one?
Yeah, go, sure.
Right. Okay. So we had represented a client, operates a small business, is trying to step away. He had gifted membership interest in that LLC to his daughter, and his daughter is eager to step in, wants to take over the business when father steps away. And he also gifted some interest to an employee who he wanted to sort of incentivize to take a bigger role, stay with the company. Company has no written operating agreement, and there was no writing to reflect the transfer of these shares of the membership interest in the company. So, which also created, in this case, an issue where it's unclear the amount of membership interest that was gifted. There's some uncertainty around that. So ultimately, the employee left the company. So now you have some errant person, sort of like this, sounds like this wife who's no longer with the company and just has interest in it, right? You have an owner who is just separate, but has ownership interest. So client faced with the issue of redeeming this former employee's interest so that he can continue with his goal of stepping away from the company and now, giving the business and leaving the business to the daughter, who remains eager to run the business. So that's this case study. And I think some of what could have been done differently is clear. We need the operating agreement, right? We need the any of the interest in writing. Will's talking about, you need to know who has the stake, right? Make sure you know that whether the person that you're gifting the interest to, or who does this employee really have the intent to stay. I think it was sort of intended to incentivize the employee, and the employee ultimately left. So was that a good decision for this person? Probably, and certainly not. And what could have been done to prevent this? Thoughts on that?
So coincidentally, I think I settled that case this morning.
What's that?
I said coincidentally, I think I settled that case this morning.
That's good.
A question based on that case. Is something you might cover in the initial planning with the original partners, how much latitude any individual partner has to give away their shares of the business without input from the others? Is that the kind of thing that's baked into an agreement typically? So that somebody can't just say, okay, I'm going to give it all to this person who you guys, you folks don't know, trust, want to work with, whatever.
100%.
Absolutely. That's
Yeah.
Start a business with someone that's a pretty intimate relationship, and generally you've got individuals that come together who are aligned in their values, in their goals, in where they see the business going. So to not include something in there in those operating documents that would ensure that you're not getting someone who's come in who's either completely opposed to those values, or who would just blow it up or cash everything out. I mean, it's essentially a ticking time bomb.
Yeah, I just trashed LegalZoom documents a moment ago, but in their defense, they usually do include that any transfer would require approval of other members. Usually it goes like this: you say, I'm going to sell my shares, and I get to first offer them to the other members. The members have some period of time to accept them or not. And then after that time, that person could then possibly sell them to a third party. It's unlikely a third party is ever going to want to buy into a company with two other guys that with two other people they didn't start with. So the shares aren't particularly marketable. But if that person want to give them away, or that kind of thing, there is almost always a provision that prohibits that from happening without the approval of the other members. And I think that Kirsten's that case brings up another kind of an adjunct. I'm going to go down another pathway here for a minute. But when that person was considering what to do with his company, he had his daughter and his employee, and that the thoughts on what to do with the company going forward and into his retirement were not well thought out. Who is it? Which person is going to take this? Are they both going to take it? And if so, how is that going to work? If you go, many times people want to consider a succession plan of having either your kid or your employee come in and take over. And let's use the employee example for a minute or two and say, all right, I've got a person who I feel a lot of dedication to. He's really been very instrumental in the growth of his company. He's been here a long time. Really, somewhat responsible for building the value of the entity that I've enjoyed. So I think that person would be the one that I'd like to sell it to. Right? Okay, well that makes a lot of sense. And if you think of that at some point, you think I'm going to retire a few years out. Great, because that person now is incented, as Kirsten was saying, or that client did, that person's incented to stick around because they say, well, I'm going to own, right? And so, and I'm going to own more, maybe 10% one year, 10% the next year, 10% then. And then at 50, maybe there's a closing where I buy the remainder of this whole place, and it's mine. and then the owner either takes off with a pile of cash, or maybe the owner holds some paper and what have you. Great plan, and totally honorable thing to do, and I think that's I like that plan. You got to be really careful with that plan, because that person who you want to sell to, who is so crucial to your success, may not have the ability to do that. And I've run into this several times where the person is the buyer, is the employee, is the buyer, and that buyer cannot finance the sale. You've got a $2 or $3 million business, and you want to sell it for $2 or $3 million, and they can finance at best 1.6. And you've given them 20 or 30% shares with the anticipation of a closing where they're going to close, they're going to get that money and deliver it to you, and now they can't. What do you do? And so you can build in some protections on the beginning of that the shares revert unless the closing occurs at a certain time. So you can have that event occur, so you can reclaim your shares. You can do something like that. But really the question is, in the beginning, is this person creditworthy, or creditworthy enough that they could go to any of the banks that we all use here and get the money they need? And maybe they can't by themselves, but do they have resources, their family, or anything else? In a couple of instances, what has happened is that the seller, in those cases, ends up holding a promissory note to that buyer for a huge amount of money, way more than or at least equal to the amount that they're paying for the business. So maybe a 50% note. And if that person, when a person buys a business from somebody who's had business for a long time, the new person who owns the business has the burden of debt service that the old owner did not, right? So if you're making $1 million a year and you're taking it all home, that's great. But if you had to pay on debt service for that business, your revenue would have been very different. So now you're holding a 50% note on this employee who you were so dedicated to, and that person is doing is best with the business. Numbers could even be the same, but they no longer have the cash flow because they have to service the primary debt, the senior debt first. And now you're stuck. And what are your remedies? If that person doesn't have the money to buy the business, your best remedy is probably taking the business back, which is not what you want. You are now, you're envisioning yourself on the beach somewhere, and your opportunity to try to make yourself whole is to go back in and start your business, which has been altered. This isn't the business that you left, and it's a really tough thing. So we, in the last year, I think we've had 2 of these deals, and they both closed, but it took a long time, and they had to get very creative with the financing. Both of those deals are still going, and I think I'd like to think they're going to be successful, but I've been involved in others that weren't, and coming back in and taking it back is tough. It's especially tough if that person is your kid, and we have had that happen too. And so you have to be extraordinarily careful about how you're going to do that. And if it's your kid and it's your estate plan to actually give that to your kid, that's one thing. But if it's actually your retirement, you actually have to have the money to live on whatever you're doing next. You have to be very confident that you've got the ability to get paid.
How often is it that these plans that go awry involve? I mean, you mentioned families are really typical. Is it often a parent to a child kind of succession plan?
Yeah, it often is. The ones that I'm talking about, the last 2 that I was dealing with were not. They were to arm's length to really long-term employees. A business, a 30 or 40-year-old business with employees who have been there 15 to 25 years. The most recent one that I had fail was a family deal where a person sold to a childless person, sold his business to his nephew, who for all intents and purposes was his son. And that person did not have the capacity to manage that business. And he had it for, I don't know, 18 or 24 months, something in that area. And our client had to go back in and sort of take it back over. And he did and had to run it. And it was significantly less valuable than it was when he left it. And he then found a buyer for it. But that buyer was a significantly reduced number from what that originally, reasonably expected price would have been. So it was harsh. He had to go back in himself and do all the work over again, and then had to sell the business. And he probably lost, I don't know, probably $2 million or so on that deal.
The reason that you see so much difficulty with transactions involving families, of course, is because you've got that emotional component. You giving it to your child because you believe and you think that they can do it, and you think everything is going to be okay. Whereas if you're a little further removed, obviously you can look at it more in a kind of bottom line type perspective.
Yeah, that makes a lot of sense. We had a comment from the audience here that I thought would be worth sharing. You had touched on employees getting equity in the potential wisdom or not of that. And this is Ed Miles commenting from the NH Small Business Development Center. He says, I know we are talking about talking equity stakeholders, but we have seen separate standalone carve-out agreements at the onset of a business for a key employee to incentivize and offer participation in success without giving up equity. Any thoughts on that?
Sure. And good morning, Ed. I know Ed. That's a great question. What Ed's talking about is sometimes called shadow stock or shadow agreements, where a person is given it's an incentive, to keep someone in a company, so they're paid in the normal course. They may or may not take a share in distributions. So if the company is going to do a distribution of, $10,000 per owner, that person might take in that, might not. The real benefit is that if the company sells, that person is treated as though they own a certain percentage of the company. And so it's a protection thing, and it allows that person to sort of know that if they stay, you've got to stay for these things. But if you stay, that you can be paid out at the end of it. Now, important consideration there for tax reasons is completely off topic a little bit, but that's ordinary income. And if you're the owner of the company, it's probably a long-term gain. And it's probably a fairly significant difference in how you get paid on that. And the most recent time I did that was a company here in Dover that was selling, and it was a roll-up. They were selling to a large equity group. And there were two owners, and there was a third owner who had shadow stock. And just before the closing, they converted that shadow stock to equity. So he got the same money he would have got, but he had his tax burden was significantly less. But that's a great way to do that. Employees are oftentimes unfamiliar with it, and it feels shaky. Phantom stock, shadow stock. There's all these names that go along with it, and they're not particularly helpful. But Ed makes a great point. It's a great vehicle. And you don't actually lose the equity in the company. You're not actually giving up the control that goes along with the actual ownership, as you go through your business life.
Since we're talking about employee retention, what are some other things that businesses can do as part of this succession planning to manage employee retention on the legal side?
Well, let's see. The two obvious ones are equity or shadow equity that allows that person to believe they've got a stake. The stake in the business is a big deal for an employee in a kind of a psychic sense as well, and that they feel invested. And so, if the owner of the company is willing to give me what either is or amounts to stock, then I feel like dedicated and I'm invested in this thing in ways I might not be otherwise. Otherwise, it's kind of tough because you're, an employee without rights that exceed employment is, really doesn't hold any other status. You can, and sometimes people do bonus out employees at certain events, which could include sale. But those are discretionary. You could write that into an employment contract. That would hope, someone might get paid out upon certain liquidation or distribution events, a merger or something like that. You could have that in there.
Would they ever bonus out on a timeline? Like, so if you stay a year, there's a bonus, and if you stay 2 years after the
Oh,
sale.
yeah, sure. You could do regular bonuses and to keep people in. I was dealing this morning with a large restaurant group client, and they're working to incent their management people to stay in just that way. We're gonna give you these bonuses at years 1, 2, 3. I think we're only 3 years into the program at that point, but yeah, that's another way to do it too.
Another sort of more general question. How often do you review and update these succession plans? Because presumably things change in the world, in the business, and so forth. And do you have a sense of how often you need to keep this document updated?
I think I would suggest reviewing your operating agreement every 3 or 4 years, kind of more generally. And I'm not sure that your buy-sell type arrangements or that type of thing are really going to change much. And if they do, they're going to have to be by some super majority of the LLC to do it, to do that. But I think it focuses attention on governance and management, which is easy to forget about. I mean, Shaheen Gordon is a professional. It's a corporation, right? And in fairness, I don't do a great job of going back and reviewing our bylaws. Every 3 or 4 years we do update them and review them. Probably not as often as I should, but I think it does refocus the members or owners of the company on not just the exit stuff we're talking about, but on broadly on governance issues. And I think that's really useful to have everyone have that at front of mind. So I'm not sure they change all that much in those instances. They may, but they may not. You may want to do things like allow people to start taking semi-retirement. There's as a person who's getting older here, it's a relevant topic as you look to, as you get older, you think maybe I'm going to work less, and so how am I going to, what's that going to do to my shares? What's it going to do to my comp? How are we going to handle that? And that type of thing that, that's something you may not have considered, and it's kind of hard to consider in the beginning of the company. But things like that are good opportunities to consider revisions.
Right. I think changing life events is a time to look at it.
Yeah.
Circumstances changing.
How about other external factors like economic downturns, global events, that kind of thing?
Yeah. In terms of, let's say that someone doesn't want to be in the business because the market has changed. And let's say in that example that company has a buy-sell where that person is permitted to decide to exit. And it just means that the value of that share, which was once X dollars, is now Y dollars. And so, your values change. You can also decide, you can decide to blow the whole thing up and say, I want out. I won't take anything. This company is failing. You take it, but then now you have to indemnify me and hold me harmless in the event that any of these creditors or, people come back at us. And that does bring up another thing Kirsten and I were dealing with this yesterday. When you have companies that have owners, those owners make guaranteed debt to lenders. And we ran into an issue yesterday on a business dispute where it's a number of different companies, a serial company. I think there were 11 or 12 of them, and they were trying to work out an exit between them. And some of those companies had large promissory notes to the lenders that were probably, dated 2019, 20, around there, 2021, and their interest rates are, very low. And if they had to get rid of the personal guarantee to allow someone to exit the company now, the bank is likely to say, well, okay, that's fine, but you need to refinance your note. And you're going to go from 4 to 8 or 9%. And that's a big difference in the company's, cash flow. So as you exit, you probably, as you're in the beginning of your company, you probably don't really have any choices. If you go to the bank, they're going to say, we're not going to take security based on the assets of this new LLC. Especially if it doesn't have any real estate. And then when you want to get out of it, exiting, just getting off the note. People misunderstand that concept all the time. You've got to get me off the note. It's not your choice. It's not the other guy's choice. It's a third party's choice. And that can be very expensive.
We have talked a lot about LLCs. I think, have all of the case studies been LLCs that we were just talking about?
Will was going to talk about one that's a corporation, but I'm not sure.
Oh, well, maybe let's jump into that. We still have 7 minutes left. And one of my questions was going to be, is there a difference in your approach to succession planning depending on the type of legal business structure that you have? And so maybe, Will, if you wanted to talk about something that's not an LLC and how that was a different approach. Well, of course, we're talking about one that went wrong too. So
Right.
Yeah. Maybe they all went wrong, right? That's why we're here discussing them in the first place. And really, the only different, I'll give you a little background on the case, but we had a client who founded a small business, appliance store, and ran it successfully for 25 years. Once again, we have an issue where there's a father-son dynamic, and as dad's getting ready to retire, he transferred, and this is a corporation, and transfers 45% interest to his son. Beyond the actual transfer of those interests, there is nothing put forth in writing, but the agreement is that dad is going to be for his remaining 55% interest in the company. He's going to receive $55,000 a year for the remainder of his life. And that's going to be his retirement. And then upon his death, the remainder of the interest go to the son. Well, that started out fine. And, because there was nothing in writing, I don't believe there was much discussion between them as far as what was dad's involvement, even though he was a majority owner of the business still, what was his involvement going to be kind of on the managerial side of things. And there were some clashes there, as you can imagine, where, son is say, hey, this is my business, you're getting your money, basically stay out. And dad was used to coming in and, you need something here or there. Let's pull it from the business. Well, as you can imagine, the relationship soured, things went south. And before you know it, the son is suing the dad, and they're going to court and, engage in a prolonged legal battle, so you've got on the personal side of things, the fracturing of this relationship between father and son. And then on the business side, as anybody who has ever litigated anything knows, that it's not simply you step into the courtroom and you're on, you step out, okay, I don't have to think about this. This is something that is with you day in and day out, that hangs over you, that impacts really almost every facet of life. So it was just a failure from start to finish. And, by the time it was all said and done, as they got into litigation, dad was no longer getting his retirement payments. So, all of a sudden there's just nothing there for him, and it's just it was a colossal failure, unfortunately. And I think, you know, highlights, as all these cases do, why it is so important to really be purposeful, you know, be intentional in that planning, and get the buy-in from either the family members, the employees, who's ever going to take over your business. That the more you understand each other, the more you are aligned in your vision, in your values, in the future of the business. And you know, it's important also to then define those roles in terms of the management, because again, at each step of that, you can get tripped up. And to the extent that there's any remaining involvement in the business itself, you know, suddenly you see somebody that has turned over the business, but all of a sudden maybe they don't like the way that it's being managed a certain way. So all of a sudden, you know, they've got their hand in here, they got their hand in there, and it breeds conflict. So the more you can plan for on the front end, the more leeway you can give yourself in terms of knowing who it is that you are turning over your business to, knowing who it is that is going to take this business, you know, into the next generation. That the more you can prepare for that, make sure you are giving it, you know, turning it over to the right person or people, and again, ensuring for the continued success of the business and accounting for those stakeholders. And I know you would ask the difference between LLC and a corporation in this case, and not, you know, other than kind of the ownership interest, the way that's structured, membership versus, you know, the stock interest. There wasn't much difference in this case. Again, you've got basically two individuals who were involved here. One turned it over to the other.
Yeah, it's shareholder agreement versus operating agreement, and it's substantially similar in corps and LLCs.
Okay, well, that brings us just about to the top of the hour. So I wanted to see if you have any things that I didn't ask about that you wanted to mention, or any other things that you want to leave people with as, you know, as a key takeaway. I could jokingly say don't have kids, but I wouldn't mean it.
Yeah.
I have 4, but anyway, there's a through line to these stories, though.
Yeah, one of the things we mentioned, you know, kind of throughout this, is that you can't start with the succession planning too early. But that's not wherever you are in the business, it's not too late. Right. I think it's just something that's important to think about. A lot of you start a business, you go into business, you think, you know, it's never going to end, or you just don't see that, or you think it's going to be all right. And it can be, and it will be if you plan accordingly. So think about it early, think about it relatively often, but think about it and get something in place that you can execute.
Yeah, I agree. We're happy to help out. I'd like to point out that Ed Miles Group is the New Hampshire Small Business Development Center. They're a fantastic resource, and I recommend people look them up.
All right. Well, awesome. Thank you. Kirsten, any last words?
No, I think they summed it up just fine.
Well, that was a fascinating discussion. Thank you all. Kirsten Allen, Will Baker, Sean O'Connell. Thank you to Shaheen and Gordon for sponsoring this webinar. And thank you all for attending this morning. It's been a great conversation. Really enjoyed it.
Thanks.
Thanks for having us.
All right, have a great day.